Welcome back, and welcome back to those online for part 2 of the conference, where Paul Stanley is going to tell us how not to run an arbitration. Paul.
Thank you. First of all, a disclaimer. I'm going to be talking about a case I was in. There was confidential information in that case. I'm going to try to stick, and I think I will stick, to material which is in the published judgment. And obviously nothing I say is intended to reflect anything other than the material in the public judgment seen in the light of history. I'm not going to focus very much, though, on the law in the judgment, because it's mostly the law that Joe has been covering this morning. It's the basic principles of impartiality and apparent bias. I'm more interested in doing two things. Firstly, in a kind of air accident investigation, because for the none of you who occasionally watch, as I sometimes do, long YouTube videos explaining why a plane crashed in 1965, you'll find that they rather interestingly often find that it's the lining up of a whole succession of small errors which actually ultimately ends up with a jet on the ground. It's what they call in the airline business the Swiss cheese theory of errors, which is that it's a succession of things which none of which in and of themselves might seem to be a problem, but when you put them together, you end up with a problem. So the first thing I'm going to be trying to do is to try to go through what happened in this case to see how it ended up going quite as badly wrong as it did go. And it did go, from everyone's perspective, pretty badly wrong in the sense that an arbitral hearing had to be abandoned at the last minute. The arbitrator was then removed by the court, which does not happen very often. So it's a serious screw up, and it's worth understanding how it happened. And the second thing is I'm going to be looking at it from the point of view of what if we were on a judge's training course we call courtcraft. Not the kind of stuff which is about the law, not the kind of stuff which is about, well, you can do that, you can't do that. But the sort of thing which is about, well, you can do that, maybe, but is that the right thing to do? Is that the right way to keep the show on the road? And that's the exercise. So the judgment, if you want to read it, 2024 EWHC 382, decision of Mr. Justice Calver in the commercial court removing this arbitrator who was called W, and I will call him W. The basic fact came out of an accident on a film set. An actor had been supposed to be throwing a Molotov cocktail as part of a riot scene. And the stunt man, or I think a woman actually, just beside him, was to hand him this Molotov cocktail and he was to throw it. And someone decided at the last minute that they were going to do two things. Firstly, that they were going to make sure that the Molotov cocktail actually contained flammable liquid, a real Molotov cocktail. And secondly, that they were going to do the very smart thing of putting the flammable liquid in a breakable glass container, in other words, something which you could normally just crush, the sort of stunt glass, effectively, that you would use if you were putting a glass in someone's face on a film set. Now, burning petrol and sugar glass don't really belong super well together. And as he grabbed the cocktail, the Molotov cocktail, to throw it, he crushed it in his hand, and he ended up covered in burns. So absolutely classic film set problem. The actual claim was about film production insurance. There was insurance which was to cover, in circumstances in which somebody was injured on the set, the additional costs and the loss of time. No particularly interesting point about that. And the underlying issues in the case were going to be whether what this actor was engaging with at the relevant time was a hazardous activity, where there were arguments about what is a hazardous activity. Does it matter that he didn't know it was a hazardous activity because it wasn't obvious to him that he was in danger? Did it matter that anyone else knew that it was a hazardous activity? That sort of question. And secondly, a question of whether there had been compliance with a condition in the policy to use due diligence and take all reasonable steps. And you can see that both of those arguments raised a mixture of actually quite interesting and difficult legal arguments about what is a hazardous activity. Is it just supposed to be, skiing and hang gliding? Or is it actually a hazardous activity if it turns out there was a hazard? And secondly, due diligence and reasonable steps. We're back to all of those cases about leaving car keys in your car while you go to the garage and so forth. What does that actually mean in the context of an insurance policy? And have you reached the stage of crossing that threshold here? So those are the issues. The arbitration agreement. So here we are at almost the first point in the Swiss cheese. Arbitration in London by an experienced practitioner in film and television production, as appropriate. If agreement cannot be reached on a suitable arbitrator, one will be chosen by the chairperson or president of the film or television production industry body, as appropriate. So in this quite typically complicated insurance contract, the parties had specified that they needed an experienced practitioner in film and television production. And what that had done is put them on the first of the collision courses, because experienced practitioners in film and television production, who are also experienced arbitrators, are, it turns out, quite thin on the ground. It's just not a standard feature of the film and television production industry that people carry out insurance arbitrations or any kind of arbitration. It's not the business that they're in. And notice also that they'd already chosen a sole arbitrator for this. So they'd given themselves both of those things as starting points. The arbitrator who was ultimately selected after a good deal of toing and froing was W. And he was indeed an expert in the film production industry. He had very extensive decades of experience in that industry, no question about it. He had no legal background at all, and by that I mean not just that he wasn't a trained lawyer, but he wasn't a person who had spent his time around lawyers. He wasn't like somebody who's acted a lot as an expert, or maybe a broker who's been involved in a lot of arbitrations over the years, or an underwriter who's been involved in a lot of arbitration over the years. He was a person who had really kept a very sensible distance from lawyers in the way that you would expect an experienced professional in the film and television production industry to do. He had no experience as an arbitrator. He had never sat as an arbitrator. He had been involved in 3 arbitrations. We don't know how. I think the inference is that he probably had been a witness in 3 arbitrations, or perhaps a party in 3 arbitrations. So he had, over his 40 years experience, 3 times had some contact with arbitration. But he had never sat as an arbitrator. He had no training to sit as an arbitrator. And he was therefore entering not only a legal world, but a cultural world in which he was not going to be comfortable. So you can see now how that first arbitration clause, Swiss cheese, is now lining up to the second cheese. The pilot who is now stepping onto the cockpit is somebody who has never actually flown a plane. He's flown in a plane 3 times, but he's never actually flown one. So tip 1, or Swiss cheese 1, experience counts. And it matters about experience of what? I'm not going to sit here and say arbitrators should always be primarily legally qualified. There are very good reasons why parties will prefer to select someone who has relevant industry experience. On the other hand, and as I've pointed out, there are arbitrators out there who combine relevant industry experience with experience of being an arbitrator. Being an arbitrator does not require you to have all of the legal skills that you need to have to be an advocate or something of that sort. You don't have to be able to cover that ground. You will have people to help you understand the law. You probably have a bit of humility about what you don't understand. But there is a craft to arbitration. There is a set of skills which a good arbitrator brings to the table, which you can't be expected to get right the first time you do it. And let's watch what happens. The third point I make is that, contrary to what people, even the people who apparently agreed this arbitration clause may think, and you see this, I think, in a lot of arbitration clauses, there is somehow an assumption that arbitration is going to be very simple. That because it is not litigation, it is going to be plain sailing and it doesn't much matter what happened. Now, maybe that reflects how things were carried on in the Baltic Exchange 40 years ago, when people would sit down with a whiskey and tell people that it was about time they sorted this case out. Maybe. But it certainly doesn't reflect the way that arbitration works now. The fourth point is, he wasn't just stepping for the first time into the cockpit, he was stepping for the first time into the cockpit on what was actually quite a tricky little case. I'm not saying it was a majorly difficult one. It wasn't fraud. It wasn't going to be hundreds of witnesses. It was going to be 4 or 5 days. But it wasn't just a kind of look-feel arbitration. It wasn't just a single point. There were a mixture of legal and factual points which were quite difficult. And so the first thing to do is for parties to think very carefully and not always just jockeying for immediate advantage about what they really want. In this case, one side had been very insistent that it was absolutely essential to stick to the very letter of the qualifications which require primarily experience in the film and television industry. They were unwilling to accept the possibility of, for example, a lawyer who had got some experience in the film or television industry, but was willing, perhaps not the same experience of being on set, but would at least understand what was going on. In retrospect, you've got to wonder whether they will have thought that that was the right decision to take. You can see at the time what they thought was, so long as this is decided by somebody who is not looking at it like a lawyer, who is just looking at it as whether who's always, after all, been on the production side and is looking to see whether he thinks the production company should be paid under its insurance policy, that must be to our advantage. And that's legitimate. It's a legitimate thing for a party to think about in choosing an arbitrator. But in this case, you wonder whether, legitimate or not, was it the sensible move to make? Come to the next slice of cheese, the protagonists. I'm not going to deal with the parties. They were both major players in their industries. But you had 2 experienced law firms who I can name because we can get them off the transcript. We have Quinn Emanuel on one side, and we have Brown Jacobson on the other side. It's quite apparent from the terms of the judgment that they took a highly adversarial approach to this litigation, to this arbitration. Again, that's not a criticism. There's a reason why lawyers take adversarial approaches. They're paid sometimes to take adversarial approaches. We are paid sometimes to take adversarial approaches. But it has consequences for the tribunal. There is a difference between how you handle a case, which is where you have people who are really locking horns hard, and a case where you actually have a lot of cooperation about how the case is going to be resolved. And the other thing which had happened, and it picks up a point which we were talking about earlier, is these 2 teams came from different legal cultures. You had an American team coming out of California, and you had an English team coming out of London. Needless to say, those cultures are different in terms of the way that they look at the actual substance of disputes. They're also very different in the way that they look at arbitration, because America in particular has a very different tradition of arbitration from England. And they are different, not always in the ways that we expect actually on the English side, but they are different in the way that they conduct the run-up to a hearing and the hearing. And they would also have had different assumptions. They'd have been coming with different assumptions about what shape a hearing is likely to take. We all think that there's a kind of pattern. We kind of tick it through in our mind. It's going to be pleadings, it's going to be witness statements, it's going to be experts' reports, it's going to be opening submissions. An American lawyer comes with a very different thing. They think there's going to be pleadings, there's going to be discovery, there's going to be depositions, there's going to be examination, direct examination, cross-examination, and submissions. They're coming at it from a different perspective, and those 2 perspectives need to be a good arbitrator needs to understand those perspectives. Now, what all of that meant, none of it's a criticism, but what all of it meant was not only was it a legally not straightforward case, it was, in terms of the kind of human resources available, it was going to be a difficult case to handle. So I've given an example of the kind of thing that the arbitrator was being faced with in submissions. This is a submission about a witness we'll talk about later. a witness who had originally given a report for one side and had then changed his, or come forward to give evidence for the insurers, and the insurers said that he'd nobly come forward. And the arbitrator questioned that in a passage that we'll see later. And this was the response that was then picked up by counsel for the insured. So absolutely, he said, he didn't nobly come forward. He switched sides, as you will see when you read his statement. His statement is unreliable, but I think you hit the nail on the head. It's highly inappropriate, the entire thing. They knew this was an issue. Apparently, they contacted him. I doubt he reached to Brown Jacobson. They contacted him, and it's highly inappropriate. And there are other issues as to him. Now, just look at the tone of that. Don't worry about what's being said. There's nothing wrong with what's being said, but we're at kind of volume 8. We're not quite at 11, but we are at 8 in that kind of submission. And those sorts of situations are difficult to handle. Generally speaking, hot bars need cool benches. Generally speaking, if this is a courtcraft thing, when stuff gets hot in front of you, the most important thing is that you're not interjecting it, because then it's become a three-way fight. Your aim as an arbitrator or as a judge is normally to cool down those kinds of discussions, because normally they don't help anybody. And you need, therefore, to be able to cool them down. And cooling them down can be quite hard because the emotional temperature in the room just rises. And sometimes it starts to catch you. Sooner or later, someone will start criticizing you. Sooner or later, it all becomes a kind of a blame game. So very difficult to handle and very important to handle it in a very cool and calm way, not getting involved. Difference in legal culture, we've mentioned already, those are always going to need careful handling, particularly by an arbitrator, because it's not your job to assume that one or other side of this difference in debate is right. The point of international arbitration is that it is international. You are allowed to have an arbitration in England which is not conducted as if it was a commercial court trial. It's not unreasonable for someone to come and say, the way we do it back in our country is we do these things called depositions, and we think they would be a great idea in the arbitration. Now, you might think that you don't think that, but you shouldn't certainly be approaching it on the basis that's a ridiculous thing to say. We do it the right way. You do it the wrong way. Those legal differences, you need to be aware of them, ready to explore them. Jurisdiction in England. London arbitration. London arbitration, English law. It just happened to be American counsel. Nothing wrong with that. Perfectly acceptable in an arbitration. And all of that meant that this would have been a challenge even for a very experienced arbitrator. So there's the second line of the Swiss cheese. We've got an inexperienced arbitrator, and it's actually a difficult horse to ride that he's getting on. Then we come to the procedure that W decided to adopt, or sort of slipped into adopting, because I'm not convinced that there was any particular decision taken about it. It wasn't choosing between two different approaches that people had, but he decided to adopt what I'll call a semi-inquisitorial procedure. He made a list of people he thought he should hear from. He thought might have useful evidence to give him about what had happened that day, or what the contract meant. He was quite interested in people's evidence about that as well. But mostly about what happened that day. And he made this long list of people, and he said, I want you to make sure that all of these people appear as witnesses at the hearing so that I can ask them questions. But he didn't really, because he didn't understand how a hearing would normally work, he saw it as a sort of meeting, I think, where anyone could kind of come and they would be asked questions by anyone who felt like asking them a question, and then they'd all go away and he'd make his mind up. And the result was that it's not a procedure I think I've ever seen anyone use. And it was disconcerting to the parties, I think, as well as, not to him, because he had an idea of what it was, but very disconcerting to the parties. But at the same time, because they didn't want to annoy the arbitrator. And the arbitrator said, I think we want this long list of witnesses. Their approach was, oh yeah, of course, we'll provide them. Or if the other side won't provide them, well, that's really bad. They're hiding this important witness that you want to see. And all of the things that you can imagine aggressive and on the ball counsel would do when faced with an arbitrator who was going down that path. But anyone sitting in this room will see some of the problems. You've got a witness, so who's going to ask the questions? Who's actually going to get the evidence out in the first place? Who's going to be allowed to cross-examine, and what are they going to be cross-examining about? Different systems have different approaches to this. If you go to an inquisitorial system, if you go to Germany, for example, it's very clear who asks the questions. The court asks the questions. The parties may suggest a question, and the judge may or may not ask the question. But all the questioning comes from the court. Nothing to do with you. If you look at the English system, it's the parties who ask the questions, and you have different rules for the people who are asking the questions of their witnesses and the other side's witnesses. And how do you apply that to somebody who's no witness? This would have taxed anyone. And there are a few cases, even in England. There are tribunals which that may call their own witnesses as a witness to the tribunal. But the general view is that it's very rare, very exceptional, very dangerous, needs very careful handling. Of course, you don't know what you don't know. I don't think W realized quite what he was stepping himself into. Anyway, there was the procedure that he decided to adopt. And just to make it clear, there's nothing wrong with that procedure as a matter of the Arbitration Act. The Arbitration Act makes it absolutely clear that the tribunal can decide all procedural and evidential matters. It can decide whether to apply the strict rules of evidence to admissibility, relevance, or weight, how material is to be presented, and it can decide, in terms the Act says, whether and to what extent the tribunal should itself take the initiative in ascertaining the facts and the law. So it's not that he was doing, in any of this, that he was doing anything that he wasn't allowed to do, but what he was doing was entering into a situation where he was doing a much more difficult thing than an arbitrator would normally set about doing, without probably realizing just how difficult it was going to be. So normally, we've got institutional rules which help to provide a clear roadmap, and he had none. Notice it's pure ad hoc arbitration. You've got established convention, which provides additional or alternative guidance. In other words, by that I just mean the fact that people know how these arbitrations go. We do them all the time. You've got two firms, they've done 100 of them. This is the way that they usually run. If you look, for example, at Bermuda form arbitrations now, you would find that they are more or less routine. And they're more or less routine because years into it, there's a pretty clear pattern for how, with few variations, for how they'll normally go. And people are usually willing to do things like saying, well, we'll have IBA rules of evidence, but we'll have them as guidance. We won't have them as holy writ. And there's not normally any debate about either of those 2 points. What ad hoc departures from expected practice do is they leave you really flying in the cloud. And not just you, the arbitrator, flying in the cloud. Notice what it's also doing. It's also disconcerting the parties. They are now also flying in cloud. So you've not only have you not got experience of how to operate this piece of heavy machinery, but the people who are in front of you who normally would have experience of that and would share a set of assumptions about how it goes are now off map. Off map and angry and fighting hard. So this is not looking great. So tip 3, in terms of protecting, at least start with an established and well understood procedural structure. If you don't have one, find one or make one. There are IBA rules. You can adopt IBA rules. There are UNCITRAL rules. You could adopt UNCITRAL rules. Your power under Section 33 as an arbitrator enables you to specify rules, effectively, or procedural directions, which are in extremely complicated forms and which operate as tantamount to rules. So find out what this arbitration is basically going to look like. And the second thing I would say is I'm not at all against innovation in arbitration. I think there are good innovations that people have made over the years which have taken us to good places. There was a first moment when someone decided, wouldn't it be a good idea to put disclosure requests into some kind of schedule so that we can actually see them side by side? Now, I'm not sure that the form that they ultimately ended up adopting was absolutely perfect, but you can fiddle with it. It was an innovation, and it was a useful innovation. The IBA rules on disclosure are an innovation, but actually it's a useful innovation. It's a system which basically works quite well. So innovation, not a problem. But it is, I think, important that when you innovate, you know you're doing it. It doesn't just happen by accident, because it needs to be kind of carefully designed and you've thought through the implications. So I would say for an arbitrator who was thinking, I think I might want to hear from a particular witness, sure, maybe there's a case in which that is actually the right thing to do. But for goodness sake, think it out in the round very, very, very carefully and work out exactly how that's going to work. And if you're trying to do that difficult thing, try to keep the rest of it as simple as you possibly can. Anyway, not so Mr. W. So there he is, our inexperienced arbitrator in his difficult case with his quite difficult counsel and his really interesting non-procedure. And then he decides to put his feet on the pedal. And it was going, some would say, commendably fast. Appointed in June 2023, pleadings complete by September 2023, perfectly reasonable timetable for pleadings in a case like this. And then in the middle of October, he had a procedural hearing. And that was the moment at which he dropped his bombshell that there were, I think at that stage, 22 witnesses that he'd like to think about hearing from. And he also ordered witness statements and experts' reports. Witness statements, I think, by the end of October, so about 2 weeks to do witness statements. Experts' reports by 2 weeks after that. Now, again, this should have everyone's hackles rising. Because anyone who's ever been in an expedited trial will tell you that they are nightmarish. They're nightmarish for the parties because you never stop to get time to think about anything. Everything gets done in a rush. And people are therefore having ideas because it takes often, even those of us who are reasonably okay at thinking about things, sometimes it takes a while for us to for the penny to drop. You see something, you think, oh, what about that? And it can sometimes be a few weeks before you quite see it. And all of that is happening in a rush, which means people are raising points late. People are raising procedural issues late. It's all a bit panicky. And you can see he put this reference onto a panicky schedule, which probably a more experienced arbitrator wouldn't have done. There wasn't any obvious reason for needing this kind of speed. It was just an insurance claim about things that had happened in the past. So speed is good, we generally say. We want speedy resolution, but speed comes with a price and it puts people under pressure. And so he then ended up on the 23rd of November having a second procedural hearing, which had been, it's not quite clear from the judgment why a second procedural hearing was being held, but it was obviously to deal with all sorts of bits and pieces of outstanding things which were to do with the hearing that was about to take place on the 5th of December. Things like exchange of submissions, which witnesses were actually going to be called. And it was a procedural hearing, you won't be surprised to hear, that went into with the fact that it wasn't quite clear what it was going to be dealing with was part of this procedural hearing. So we go just before the hearing and after a very rapid preparation process into a procedural hearing with relatively broad parameters where neither party quite understands what's going to come out. But we are literally on the brink of the hearing. And what he mostly did, as the judgment describes, is he mostly was talking about the witnesses. Some of them, the witnesses that he might want called, some of the witnesses the parties were going to call. He'd done his work, he'd read the witness statements, he'd read material that he'd been given, he was perfectly diligent, and he was very ready, as we will see, to share the fruits of that diligence. So the effect of all of that being at pace was that there was really only 6 weeks for evidence and submissions before the hearing was due to start. And a second procedural hearing just before the actual hearing. And that is super tight. So tip 4 is we are trying to resolve disputes as rapidly as we can, but do give the parties time, the time that they need. Anticipate problems. In other words, build into the timetable the moments, whether or not you reserve hearing time, but the moments at which things can get back on track if they've gone off track, and have a plan for how to resolve them. So back to my pilot, who is kind of sitting metaphorically at the back of some of what I'm saying. Ideally, you want to have, when you set off, you have an alternate airport that you will go to if you can't land at the airport you're planning to land at. And as you fly in, you have an idea for what you're going to do if, for some reason, you have to go around. And in the same way, as an arbitrator, you don't want to raise a lot, but you do want to stop and think, have I got enough time built into this that there are moments at which, if something goes wrong, we can get this back on track? Because what happens if that doesn't happen is everyone will start working in a very panicky way, and the hearing goes agley. And then he came to the hearing, and he was transparent. He certainly let you know what he was thinking. He was not a difficult tribunal to read. I say you, I wasn't at the hearing. So I've given a few examples. Okay, look, I've got 12 witnesses I would like to appear. For me, I don't need to hear any of the expert witnesses. I don't think they will add any value. I know what they're saying. They are exceptional people in their fields. They are the best. But I don't need them to say what is normal on a film. I know what is normal on a film. Look, if you want to cross-examine the expert witnesses, that's fine by me. But I don't think we need to listen to them. I know them all personally extremely well on the insured side. I don't know your expert witnesses. You have an expert underwriter, but I don't think he adds much. Now, this is more or less stream of consciousness material. This was actually the thing which this little exchange is the thing which ultimately got him in, one of the two things which got him into pretty bad trouble. This was the worst thing that he ended up doing. There was an issue about how you should organize safety on the set. And it was generally agreed that mostly it's the responsibility of the producer. But there was an expert witness for the insured who was going to say, no, things are different in Norway, I think, or maybe it was Sweden where the thing had happened. But anyway, a Nordic country, which it works differently there. So the arbitrator, JJ, he says, that's the witness, in his report states that the role of the stunt coordinator is being in charge of safety on set. In other words, not the producer, stunt coordinator. He doesn't need to appear. He's one of the top Norwegian producers. And what he says is what I will believe. But what he said is not how it operates in the rest of the world. He says stunt coordinator is in charge of safety on set in Scandinavia. I absolutely believe what he said. But it's not what happens elsewhere in the world. If that's what he said, I would accept that. Counsel for the insurer then said, with respect, I hope that you will reserve your judgment until you've heard the evidence and submissions at the hearing. I will, of course, reserve my judgment, but I've read the statements and I know the professionals. I can say now what I think. And then he was very talkative. This you won't, I'm afraid, be able to read, but it's worth reading because it just getting the flavour is part of why you'll understand why the court did what it did. This was about the witness who changed sides, where I showed you the rather kind of ballsy submission that the insured's counsel made about that. So it's, well, look, says the arbitrator. From my point of view, I believe that his evidence to either party should be disallowed. I don't think we should allow it. He cannot change sides halfway through. I think it's absolutely wrong. And then this is counsel for the insured. It's not privileged, sir. Secondly, he was brought in as an independent regulator. What he's produced was sent to the regulator. There's no conflict. He has material evidence to what was said by people at the time. That's highly relevant. Well, when I saw his report, I thought it was highly relevant, but I had no idea he was working for you. Well, that's unfair. One has to ask why he's doing that. With due respect, he was not there. Why is he a witness? Well, he's a witness as to what was said. Look, what he said in his statement, his examination and interviewing after the event is very relevant. But now he's switched sides. I find his action incredible. No doubt he'll be cross-examined, but might I suggest you give him at least a chance? Mr. Purchase, you are a fair man. Surely you can see that if someone has switched sides halfway through, I don't see it that way. He was an employee retained to conduct an investigation. The insurer have called him as a witness, not because well, look, he's a gun for hire, it seems to me. Has any payment been made to him? Nothing conditional on his evidence. And then the example of the needling, the other side put in, well, you didn't answer the question that was asked. Nothing contingent on his testimony, but he is being paid. Now, can you see what's happening? It's just an endless chatter, essentially. And the judge's comment on that particular exchange was that it showed the inexperience of the arbitrator. The fact that the insurer was calling this important witness was no basis upon which to disallow his highly relevant evidence. The arbitrator was rather unfortunately egged on by the insurer's representative's suggestion that it was highly inappropriate for him to be called by the insurer to give evidence. It plainly was not. A bit more of his chatter. No, we've seen that one actually. So, tips. Tip 5, shut up. Really, really shut up. I mean, almost always, when you sit as an arbitrator or as a judge, you will say, I'm not going to be one of those talkative judges. You go in, and after about 20 seconds, you start saying something. And then the dam bursts, and you can't stop. It is very hard not to talk. Sitting as an arbitrator is sometimes quite boring, because you have to let people run the case the way they want to run the case. And the temptation is always to intervene and tell people what you're thinking and start involving yourself in what's happening. But it nearly always makes it worse when you do that. If someone's going to run their case badly, let them run their case badly. You get a moment to speak, and it's when you write your award. It's not meant to be a constant flow during the hearing. If you are going to talk, notice that the arbitrator was always expressing views. He was never asking questions. You can often make the same point by asking a question, but you'll never be picked up for it. If the arbitrator said, is it really appropriate for a person who was employed by the insured at the time to be giving evidence for the insurer? Is there any reason why his evidence could be disallowed? You'd have had essentially the same signals being sent, but they'd be being sent in a way which nobody could have criticized because it's a question. Now, I don't mean do that in a bad way, but that's normally, as an arbitrator, you should be thinking of mostly asking questions while the hearing is going on. The questions will sometimes show the way you're thinking, and that's fine, but questions are really what you're there to ask, not observations. Don't decide things before they need to be decided. Postpone every decision to effectively the last possible moment. So don't decide things that you're never going to need to decide, because all you can possibly do in those circumstances is present a potential appearance of having approached the case in a one-sided way. Don't decide now the things that can be decided tomorrow. You may not yet have all of the relevant material for it. Put off to the last realistic moment every decision that you have to take, which means for everything substantive, everything that's going to end up in the award, it means everything. And you should be the one to show that you're reserving judgment. I don't know if you remember, in one of those exchanges, it was James Purchase who had to say, well, I hope you're going to allow this person to reserve some judgment. And the arbitrator said, of course I will reserve judgment, but I know already what I think. It should be you that's making it clear that judgment is reserved. If you ever do, and sometimes on procedural issues you'll need to cut things through, say, well, provisionally, my view is I'm looking at it like this, but obviously I'm persuadable. It looks better. Now, even that, well, comes later the thing. And I'll deal with the law now. It's just a side note, because I'm not mostly trying to decide on the law, but I do particularly want to comment on this idea about prejudgment and comments in the course of hearings. Judges aren't stupid. They judge things, so they know how judicial minds work, and they know that nobody decides a case by simply sitting there like a sponge, loading up with arguments and thinking nothing, and then running a program when the hearing is over and squeezing out an award. It's not the way it works. Everyone's mind is going one way or another as you hear arguments and you hear evidence, and you always have a kind of a sense in which you're leaning. It follows from that provisional statements of view on relevant material are likely in general to be okay. So long as they are provisional, and so long as it's clear that the material is relevant material, you will get away with a lot. It's not to say you should. My recommendation is don't. Shut up more than you think. But you would not actually, even in this case, the arbitrator would not ultimately have been removed if he'd stuck to his comments about disallowing that evidence from the witness who changed sides. He'd said just enough to show that he was at least prepared to listen to it, that the judge would have said, that's okay. It was the stuff he said about the expert that if he says it, I will believe it. That was what got him into real trouble. The difficulty here was not just the terms on which it was expressed, though it was those terms, because any of us who've been in hearings can see which way the wind was blowing in those exchanges. It was the fact that he was basing what he was saying on extraneous considerations. He wasn't saying, I don't believe this witness because I've heard him and I don't find him to be credible. He said, well, if he's changed sides, I'm not even going to listen to him. So it's the presence of the extraneous consideration, which is really the extra thing which is important in this case. And I think there's a way of analysing almost the whole of the law of bias as being about the extraneousness of the consideration. If you go back to things on the orange list and the red list, the reason they're on the orange list and the red list is because they're not relevant. They can't be relevant to anything that is about deciding the case. And if you're deciding the case because you are a shareholder of one of the parties, or because you've done a lot of work with one of the parties, then you are bringing extraneous matters into the decision. And that's what bias is really about avoiding. So, nevertheless, just because you could express a provisional view doesn't mean that you should. Silence often speeds things up. This takes a bit of time to learn. When you are sitting there thinking, this is terrible rubbish that this awful man is shouting at me, I really don't want to listen to this awful argument any longer. It's now 10 to 4. He's been going on for an hour. Must he? The temptation is at that stage to intervene. My experience is that will slow him down. The best way to get it over with is just to sit there and let them go on with it. There's nothing like silence to let annoying counsel with bad arguments just run out of steam. Questions, as I've said, better than statements. So I think you can see the holes in the cheese beginning to assemble. The last hole, the arbitrator was desperate to show his experience, probably partly because he wasn't experienced. And so he said things like, I know all three very well. I'm extremely good friends with them and GE. I know them all personally extremely well on the insured side. Now, he was bigging himself up as this expert in the industry. He didn't realize there was any problem with this, I don't think. Now, in fact, he was actually, if anything, over-bigging himself up. When there were further questions asked of him and the witnesses after the hearing was over, it became clear that actually his actual knowledge of the witnesses was absolutely ordinary and reasonably distant professional acquaintance. The sort of thing you would expect of somebody in a market. And that would not, on the authorities, have been problematic in itself. But he didn't disclose the detail until later when he was asked for it. And the full picture didn't emerge until the insured served their witness statements. And the result was that it ended up looking like he was in a position which was much different from what he actually was, and more worrying than it should have been. And then you ask yourself the question, well, why did he say that if it wasn't really true? Why is he saying, I know them extremely well, I will believe them, if actually he doesn't think he knows them extremely well? So tip 6, and I'm not going to deal with this for long because it covers Joe's territory, disclosures explicitly. Don't rely. If he'd said before the hearing, here is what I know about these witnesses, that would have been great. Instead, it all just kind of emerges. It kind of squeezes out in the course of the hearing and afterwards. Do it in advance. Be scrupulously accurate about it. Don't say that your acquaintance is, I know someone extremely well, if the reality is, I have seen this person 5 times in the last 10 years. That's not knowing someone extremely well. I think probably even in the film industry. So my overall assessment is that this is a classic Dunning-Kruger effect case. So there's Dunning-Kruger. It's a known psychological fact that if you ask people how good they are at something, the less experienced they are, the better they will tend to say they are compared to where they actually are. So the red bit, the square dots are where these people, how good the people said they were, and the diagonal dots are the ones of their actual competence. And so the really incompetent people think that they're much more competent than they really are, and the really competent people actually think that they're slightly less competent than they really are. And so when you put an inexperienced sole arbitrator, possibly having a little bit of the Dunning-Kruger moment, to decide a relatively tricky dispute without clear procedural ground rules and without himself defining any clear procedural ground rules, and innovating and at speed and volubly and carelessly, you end up with the kind of mistake that you can see happened in this case. And it's worth noting all of those points because, like the Swiss cheese model, there were many opportunities at which this arbitration could have been kept on the road. Many moments at which it could have been rescued from the disaster that it probably ended up being for one or both of the parties. And it didn't happen because nobody noticed the holes lining up. Thank you very much.
Thank you, Paul, very much. Now, without wishing to embarrass themselves by revealing their own errors, does anybody have any questions they want to raise to Paul? Thank you.
Assuming both sides had similar concerns for different reasons about the quality of the arbitrator and everything else, is there not, under the rules, that person does have the ability to recruit or hire an independent person to guide them on the procedural actions of the arbitration? How do you gently suggest that to the arbitrator that maybe they need to put someone else in the mix?
Well, I think I think there's a sort of games problem here. Let's just think about how the sides might have thought about it, and I'm not saying how they did. I wasn't actually involved in the arbitration. You've got one side that says, we think we have an arbitrator who is very incompetent but on our side. And you've got another side that we think we have an arbitrator who's going to be dead against us, but at least he's incompetent. The danger that you have in that situation is that actually it becomes in neither side's interest to sort the problem out. Because on one side, you're hoping that you're going to get an award in your favor, which is going to be just good enough to scrape through a Section 68 challenge. On the other side, you're suspecting that you're going to get an award against you, and you're hoping that it's going to be bad enough not to escape a Section 68 challenge. So as counsel, you're not always, there comes a point in the process where it ceases to be in anyone's interest to do the right thing. And there would have been no embarrassment, I think, in saying, Mr. Arbitrator, we're extremely grateful for the fact that you have a wealth of experience in the industry. But these kinds of arbitrations can be tiresome and troubling. You may not know, but it's possible to appoint either an expert or a tribunal secretary or somebody like that who may be able to assist you on the procedural side and help you to run the arbitration. Could have done that. But until it was too late, nobody wanted to. And then once it was too late, actually people's strategic pressure was going in the opposite direction.
I'll just be clear, Paul. This person was not appointed by bodies such as ARIAS UK.
No.
Which well-known arbitral institution appointed this person?
British Film Institute. Making, I think, its first foray into the world of arbitral appointments. And possibly its last.
What happened to the case?
I don't know. I mean, the arbitrator got removed. What happened to the actual case, I don't know. And I suppose if I did know, I couldn't tell you, but I don't.
Any other questions for Paul in the room or online? No, well, thank you all very much. And thank you, Paul, rather, very much indeed.